Hello, very nice to see you all. Welcome, dear participants, to the guest lecture of the module of this week on Law of the Sea. It's nice to see you again. Today we have the great pleasure of having with us Judge Tullio Treves. Warm welcome to Judge Tullio Treves, who is a very well-known figure in the law of the sea world. He's been an academic, based his career in Italy, teaching in several universities, including the State University of Milan. And he has also held various positions in terms of the diplomatic and international world, including being legal advisor to the Italian mission in the UN in New York, and also, and most importantly, a judge of the International Tribunal of the Law of the Sea. Currently is a senior international law consultant with a law firm called Curtis, Mallet, Prevost, Colt and Mosley, LLP. They always have long names. That is in the Milan office, an arbitrator, a counsel in several international cases, and is also a confrère, a member of the Institut de Droit International, and a member of the Curatorium of the Hague Academy of International Law. And we are so happy, dear Judge Tullio Treves, on behalf of Nilofer Oral, myself, the eAcademy participants, we are so happy to have you today. Judge Tullio Treves will be speaking to you on the impact of UNCLOS on international law and the settlement of international disputes. And so with this, I give you the floor, dear Tullio. Again, thank you so much for joining us. We will have some time at the end for the participants' questions, and we look forward to that also. Please, Judge Treves.
Thank you very much. It is for me a great honor and pleasure to lecture in this prestigious academy. And my lecture will be not completely, not exclusively concerning the law of the sea, but it will try to see the connections between the law of the sea and in particular the UN Convention on the Law of the Sea and general international law. Indeed, the UNCLOS, or United Nations Convention on the Law of the Sea, is a very peculiar instrument, and it is worthwhile to look at it from the viewpoint of general international law. The special characteristics of the United Nations Convention are many. I will just mention, first of all, a few. First of all, is a very extended text. It's a huge book, you probably can see it, of about 400 articles, and not all the articles are short. And it has also a very big membership. This is a convention that counts 268 contracting parties. So it is, let's say, a huge piece of work in international law. A big text for many, many states. And it has also certain particular characteristics, not only as far as the settlement of disputes is concerned, of this we will speak later, but also because it gives great importance to international institutions. It is a convention that provides for the setting up of one general, one institution of general purpose, the International Seabed Authority, which has as many state parties as there are parties to the convention. And then it is a convention that gives importance to institutions, to organizations, those that already exist, and also those that are supposed to be set up. So we have a convention that is quite different from many other law of the sea convention and many other international law convention. And I would like today to concentrate on two different aspects. The first is a comparison between the techniques for the codification and progressive development of international law followed in general in international law, and those followed in the Third UN Convention Conference for the Law of the Sea that has produced the UNCLOS. And the second aspect I would like to mention and to speak about is about a special aspect of international law, namely the settlement of international disputes. To be more precise, the arbitral and judicial settlement of international disputes. This is a problem, a kind of question that exists in many aspects of the international law, but in the case of the Law of the Sea Convention, it has very particular and important special aspects. I will now start, if I may, with the first part of the program I have just announced. Namely, I would like to speak of UNCLOS and the codification and progressive development of international law. The codification and progressive development of international law is a task that the UN Charter reserves for the UN General Assembly. And indeed, this is something that deserves to be looked into some detail. The codification, first of all, is there a difference between codification and progressive development? Well, in general, one considers that codification is an activity that transforms into treaty norms or conventional norms certain provisions, certain rules of customary law. It is a process through which customary rules are incorporated into written rules, in most cases, convention, rules of international convention. The United Nations has developed a very special technique for the codification and progressive development. The difference being that codification would be faithful to customary rules, while progressive development would go a little bit beyond and add some new elements to customary rules. And the United Nations has developed a special technique based on a peculiar organ, the International Law Commission. This is a body constituted of experts, persons who work in their personal capacity, but still they are elected by the General Assembly, and so there is an element, a political element in the constitution. The International Law Commission has developed a manner of dealing with matters of codification of international law. The Commission tries to select subjects that it considers ripe for codification, and then entrust the work of preparing reports on this subject to one of the members of the committee, who is the rapporteur. The rapporteur produces draft texts that are discussed by the International Law Commission and transformed into, how would I say, into draft texts that are submitted by the International Law Commission to the United Nations, namely in particular to the Sixth Committee of the United Nations. And so there is an engagement of experts in the preparation of texts that are supposed to reflect existing international customary law and to help making it progress. So in normal situations, the codification of international law is a task that is entrusted to the International Law Commission, its experts, and later it becomes something more binding. And this is the normal mechanism. For instance, the mechanism followed for the Vienna Convention on the Law of Treaties, the mechanism followed for the Geneva Convention on diplomatic immunities, but it's not what has been done as far as the Law of the Sea Convention is concerned. The Law of the Sea Convention, from the early steps taken in the third UN conference on the law of the sea, is a convention produced by a conference of states, experts. The International Law Commission is not involved in this. The states debate the materials and produce text, and through a very peculiar mechanism. Of course, when we say, and all authors speak of this, say that experts like the members of the International Law Commission have had no role in the preparation of the Law of the Sea Convention. We say something that is true, but not completely true. In fact, the Law of the Sea Convention as we have it now is very much connected with the Geneva Conventions on the Law of the Sea of 1958. These are an earlier attempt at codification by the United Nations based on the work of the International Law Commission. So we can say that the Law of the Sea Convention, as we have it now, in a certain measure, is also connected with the work of the International Law Commission, because the International Law Commission was the author of the draft of the Geneva Conventions, and many elements, not all, of the Geneva Convention have been incorporated in the Law of the Sea Convention of 1982. It is, I think, worthwhile to consider the special techniques that the Law of the Sea conference, the third UN Law of the Sea conference, has adopted to work on what was to become the UNCLOS, the United Nations Convention on the Law of the Sea. First of all, and we have already mentioned this, there is no role for the International Law Commission. The International Law Commission is not a party to this, to the preparation of the third of the work of the third conference on the Law of the Sea. The third conference on the Law of the Sea was a conference of a purely political nature. The parties to the conference were states and only states. And indeed, the delegates to the Law of the Sea conference were, I would say, the most active diplomats with an expertise on law, on international law, and in particular, Law of the Sea. These people worked to produce drafts that became later the Law of the Sea Convention. But the technique adopted was quite peculiar. The Law of the Sea Conference tried to achieve a result, a convention that was to be universal, namely was to be a convention applicable to all states so that it would be a universal text. Of course, this result, as you all know, has not been reached in its entirety. We have now a convention that has many parties, 168 parties, but there are also some states who participated in the convention that in fact are not party to the end product of this effort. They are not parties because they feel that they do not agree with certain aspects of the convention. This is a position of a minority, but it must be taken into consideration. Of course, we may say that the most important states that are not parties to the convention include the United States of America, who had a very active and important role in the negotiations, but which did not feel that it were to ratify or accede to this convention. And then another aspect that characterizes the codification technique of the Law of the Sea Conference and the product of the Law of the Sea Convention is a device that was introduced in the negotiations and which it's called the negotiating text or the informal negotiating text. In what does this consist? The state parties to the Law of the Sea, the third Law of the Sea Conference, entrusted to the officers of the conference, the president and the chairman of the main committee, the task to produce a text that would correspond to what these persons considered the most acceptable solution for the text of a future convention. So this, since early on in the conference in 1975, the officer of the conference produced what in the first version was called the single negotiating text, namely a text containing provisions that, in the view of the authors, were those who had more chance to be generally accepted. And this technique had the effect to concentrate the discussions in the conference on these special single texts, so that there was no reason to add new provisions. It was just a question of adapt and these single texts to what seemed to be the best solution for the negotiations. And indeed, the conference progressed from one single text to another, these texts becoming every year a little more negotiated texts and a little less negotiating text. And at the end, the text was a draft convention, and then the Law of the Sea Convention, who was adopted in 1982. Another aspect that perhaps is interesting to underscore is that the Law of the Sea Convention is in some way a flexible text. The parties have adopted implementing agreements that modify and amend in some ways the convention. So the convention contains provisions for amendment, but they are never used. What is done is to adopt special agreements that implement, let's say, make the convention more complete. You have a special agreement for in matters of seabed mining, which has become an integral part of the convention. And then more later, the straddling stocks agreement, which developed 2 small articles in the convention. And in the present time, there is a diplomatic conference going on at the United Nations, which is in the process of adopting a text, a binding text on matters of the text, the so-called BB&J, the mechanism, the resources beyond the limits of national jurisdiction. And this is what is on the negotiation now, and we'll see probably over the few months or year or two what comes out of this important work, which, by the way, is under the chairmanship of a diplomat from Singapore. And before we finish on this first part, it seems important to underscore that the relationship between UNCLOS and customary law. First of all, UNCLOS provides for a role to customary law from 2 viewpoints. The first is that, and this is not even said in the convention, but it's obvious, the non-parties to the convention, they are not bound by the convention as such, but they are bound from general international law, namely customary law. And the second aspect is that customary law continues to regulate matters that are outside of the scope of the convention. And this is said in very explicit way in the preamble of the convention. The very last preambular paragraph affirms that, and I'm quoting, that matters not regulated by this convention continue to be governed by the rules and principles of general international law. And general international law is a way to address the idea of customary rules. And indeed, the convention aspires to regulate everything that has to do with the law of the sea. But this is an aspiration that is not always well-founded. There are many new problems that emerge in the law of the sea that in some cases may be encompassed by existing rules of the convention, but in many other cases they are not so encompassed, and so the customary rules become very important for their regulations. And apart from this, a very important question is whether the convention as such, a convention that has so many states that are bound by its rules, has an impact on customary law. Can we say that the convention codifies customary law as it now exists? Well, certainly when the convention was adopted in 1980, you couldn't say that it corresponded 100% to customary law. There were many aspects that were different and not corresponding. But certainly one must consider that a convention that binds 168 states through the years has had an impact on customary law. And so even non-parties or maybe bound by these rules because of the influence of this convention on non-written law. It's difficult to say whether there is a presumption of conformity of the rules of the Law of the Sea Convention with customary law. But certainly one has to consider this possibility, and probably the impact of the Law of the Sea Convention on non-written law is developing. I will now move to the second part of what I wanted to tell you this morning or afternoon, depending where we are. And this is the impact of the United Nations Convention on the Law of the Sea on the settlement of international disputes. First of all, we must underscore that judicial and arbitral settlement of disputes has played an important role in the development of the Law of the Sea, even before the Law of the Sea Convention was adopted. We could just consider two very simple historic facts. The very first the very first case settled by the Permanent Court of International Law. Sorry. So, sorry, I had to stop a machine. The very first judgment of the Permanent Court of International Law in the 20s was the Lotus case, a very well-known case in which was a law of the sea case about how do you say it, about two vessels that were in hitting each other. And then the first case of the United Nations Convention of the International Court of Justice, as we have it now in The Hague, the very first case was the case of the Strait of Corfu, a very important decision concerning the law of international straits, innocent passage, and so on. Again, a law of the sea case before codification convention came into play. And if we look, for instance, at the Geneva Conventions on the law of the sea, we see that certain provisions, for instance, those on strait baselines, are taken from the work of the International Court of Justice. So certainly settlement of disputes plays an important role as far as law of the sea in general is concerned. And this is reflected and underscored by the third United Nations Conference on the Law of the Sea and the UN Conference on the Law of the Sea. Most codifications conventions, including the Geneva Convention, have rules on the settlement of disputes, but they do not have rules providing for what we could call compulsory jurisdiction of international courts and tribunals. Namely, they do not have rules that permit to a party that considers it has a dispute with another party to put in motion, to trigger a proceeding before a judge or an arbitrator. While compulsory arbitral or judicial settlement is the key innovation of the United Nations Conference on the Law of the Sea. The convention has a very developed part 15, concerning the settlement of disputes. And the heart of part 15 is section 2, which permits to a state to start a procedure before a judge or an arbitrator. And this was an important step forward in the history of codification and progressive development, because, as I mentioned before, many prior codification convention did not contain this possibility. They provided that states may go to judges and arbitrators if they agreed to do so on the basis of ad hoc agreements. While in the Law of the Sea Convention, we have this possibility of putting in motion proceedings unilaterally by state parties. Of course, this is what you will see in Articles 286, 287, and following of the Convention. The mechanism, the states, however, while they came to the agreement that compulsory settlement was a good idea for the Law of the Sea, they had difficulty in agreeing on which body, which judge, which arbitrator would exercise this compulsory jurisdiction. Certain states, parties to the conference, thought that the best solution would be to entrust this task to the International Court of Justice, because the International Court of Justice was already in function. It had not too much work at the time, but other states didn't like the International Court of Justice because they thought that in the selection of the judges of the International Court of Justice, the Security Council, namely in particular the permanent members of the Security Council, had a role that was too much for their taste. So they said, we can accept a special tribunal specialized in the law of the sea, perhaps similar to the Law of the Sea Convention, but not the Law of the Sea, not the International Court of Justice. We need a special Law of the Sea tribunal. Other states said, we don't like anything pre-organized, we prefer arbitration. And some said, we prefer specialized arbitration and so there were many, 4 possibilities on the table: International Court of Justice, arbitration, Law of the Sea Tribunal, and specialized arbitration. At the end, a formula found by expert members of the delegations in a meeting in Montreux near Geneva came to the idea, well, if we cannot adopt a preference, we can prefer all the mechanisms that are on the table. And so the provision that now is in Article 287 was adopted. Namely, it was decided that states would be entitled to make a declaration expressing a preference for one or more of the 4 mechanisms I mentioned before. If in a specific case, the 2 parties to the dispute had expressed the same preference, this would be the competent tribunal. But if there was no preference expressed or different preference expressed, of course, you had to take a decision, and the conference decided that the competent judge would be an arbitral tribunal, so-called Annex 7 arbitral tribunal. And in fact, while there were not many preferences, these declarations were not very numerous. Practically about 2/3 of state parties did not make a declaration of preference. And so they, under the convention, they are deemed to have accepted the arbitration. And in fact, what has happened in most cases, starting after the entry into force of the convention, is that the case was begun with a request to set up an arbitral tribunal. Very often, the arbitral tribunal was the body that dealt with a specific case. In some cases, a few cases, the parties agreed to transfer the dispute from an arbitral tribunal yet to be constituted to the law of the sea tribunal or a chamber thereof. But this is because of the will of the parties. Of course, compulsory jurisdiction, which is the basic new idea in the law of the sea convention, is not without limitations and exceptions. May I just mention that states can declare that they don't wish to be bound by compulsory jurisdictions in matters of delimitation of maritime zones. And this is a declaration that quite a few states have made. Or that on military activities. But we must perhaps, before we finish, underscore that there is a fundamental limitation, so to say, ratione materiae, to the compulsory jurisdiction of judges and arbitrators. If you look at Part 15, you can read practically in each and every article of Part 15, there is a mention of disputes concerning the interpretation or application of the Law of the Sea Convention. This means that the mechanism for the settlement of the compulsory settlement of disputes concerns only disputes which have as their object the interpretation and application of the Law of the Sea Convention. And so this is an important limitation, because in real life, not all the disputes can be classified as Law of the Sea only or something else only. And so if we think at one example, this is the example of the so-called mixed provisions, mixed disputes. Disputes in which the discussion is not only on matters of law of the sea, but also on other matters, in particular sovereignty. For instance, if you take a case that was decided by an arbitration tribunal, this was the Eritrea-Yemen case. Here, the parties were in dispute about the sovereignty on a certain group of islands and about the consequential maritime boundaries between these islands. The arbitral tribunal could decide without difficulty on both aspects, because the compromise, the special agreement, covered both the sovereignty aspect and the law of the sea aspect. But this kind of dispute would not function if the basis of jurisdiction was to be the law of the sea convention, because the law of the sea convention deals only with matters concerning the interpretation of the law of the sea convention, and the law of the sea convention does not contain any provision concerning sovereignty on land. So this is an important limitation that has to be taken into consideration when we consider the otherwise very powerful and progressive mechanism for the settlement of disputes. A final point that perhaps it is worth mentioning is that the law of the sea convention contains, for certain situations, the possibility of the so-called compulsory conciliation. You know that conciliation is a mechanism for settlement of disputes in which there is a conciliation commission, and the report of the conciliation commission is not binding by definition. But the law of the sea convention in certain cases admits so-called compulsory conciliation, which is not a conciliation in which the report is compulsory, but a conciliation to which it is compulsory to submit. And this has been experimented rather recently in a case between Australia and Timor-Leste, where the parties have accepted to submit, to work for conciliation, and with quite a successful result. Well, I think we can now stop, and I am very happy to answer questions if there are some.
Thank you so much, Judge Treves, for such a detailed and comprehensive presentation on, I think, these two very important aspects of UNCLOS. On the one hand, the impact on international law and the development of international law, and then the second one on the dispute settlement. And indeed, part 15 of UNCLOS is probably one of the most sophisticated, if not the most sophisticated dispute settlement provisions in a treaty. So I open the floor to the participants, please, through the chat or by raising your hands. Let us know if you have a question for Judge Treves. I'm trying to monitor. Okay. I don't seem to see. Okay, we have Valerio from Italy. Please, yeah, you can ask your question.
Well, actually, sorry, just actually, I'm from Singapore because I'm working at the Center for Maritime Law here at NUS. But yes, I'm from Italy, sir, and thank you very much for your experience that you take to us. And I had actually, you mentioned several points that I would like to ask you. But the first one, I mean, deals with your experience at UNCLOS 3. How did you like? How was the atmosphere that there was there? How was the feeling that you had that in such a no, you mentioned the political character of UNCLOS 3, but do you think today that the goals that there were like that were planned at that time have been achieved today, or there is space for improvement? There is, I mean, whatever that you can compare with the atmosphere that there was at the time.
I must say the Law of the Sea conference was a very active and exciting exercise lasting many years. And indeed, you had under the same roof probably the best international lawyers or diplomat international lawyer of the time. And there was really a feeling that something important was being achieved. Of course, not everything came out exactly as one had hoped, in particular as regards the so-called seabed mining part 11, which after all was a part based on an activity that did not exist yet. It is just beginning to exist now, many years later. So what was really important was the real law of the sea. What you have, the creation of the exclusive economic zone of archipelagic waters, the new definition of the continental shelf, the new rules on the settlement of disputes. All this was new and very exciting.
Thank you very much, Valerio, and thank you, Judge Treves. Perhaps one final question from our participants.
If I may, I have another question. If
Please, please.
Well,
today it's Singapore, Italy.
Singapore, Italy today. Well, I just wanted to, as far as I know, it's maybe your last case, the North Star case, that you were ad hoc judge, and I don't know, like I know that was also a case that had some. There was a lot of consideration for new conception of jurisdiction of coastal states and flex states. I mean, how did you feel also in that judgment? What, if you have any consideration to share with us?
Well, you know, that case was about freedom of navigation, and the interpretation of that was, to my mind, a bit exaggerated. I had to write a dissenting opinion both in the judgment on jurisdiction and on the judgment on the merits. And it was a dissenting opinion, not especially the second one. I was one of 5 or 6 judges who dissented, not an individual thing of the ad hoc judge.
Thank you very, very much. So we're just on time. Perhaps maybe we have a question on the chat, just one final one from Duc Nguyen from Vietnam. Oh, okay. I see. So it's on sea level rise, the issue of sea level rise. Sea level rise poses some legal issues, especially sea delimitation. My question is your opinion that should we change the UNCLOS or change the baseline of states? What is your opinion? So, of course, this is a question that is very dear both to Nilofer and myself, but it would be very interesting to hear in just 1 or 2 minutes the answer about whether UNCLOS should be changed to take into account sea level rise.
Well, frankly, I am very reluctant to, let's say, to accept the idea of changing the UNCLOS. Perhaps a different approach would be to prepare a special agreement on this matter. But UNCLOS is, it is very difficult to change a convention of that, because one state may like to change the rule on sea level rise, but others may wish to change everything else or many other things. So I think that the interest of the international community is not to touch the Law of the Sea Convention. However, there is a possibility to imagine special agreements outside of the convention. But of course, the International Law Commission is doing a very substantial work, and we'll see what comes out of it.
Well, one of the positions that we took is that we're not going to make proposals to change UNCLOS. So that's also already part of the answer. So again, dear Judge Tullio Treves, thank you so much for taking the time to be with us, and for your generosity in sharing your experience, your expertise, your vision of the contributions of UNCLOS to international law in general and to the dispute settlement mechanisms in international law. And since we are in the virtual world, we will give you a virtual round of applause. Thank you so much, and hope to see you again soon at another occasion. So for the participants, thank you so much for your active participation today, and tomorrow we will continue with the Law of the Sea module with Prof. Beckman and Prof. Tara Davenport, and then next week we will move on to climate change law. And I do appreciate, I'm seeing a lot of messages in the chat thanking Judge Tullio Treves and appreciating his lecture. So thank you very much, and see you next time.
It has been a great pleasure to be with you.
A privilege for us. Thank you.